Uh, Good afternoon, everyone. Welcome and thank you for joining our webinar today. I'm just waiting a moment or two while I can see that the participants are still joining the webinar. So I can see the numbers going up steadily. Give it a few more seconds to see how many we can get. I think I'm going to start now. All right. So I'm going to say welcome again. Thank you for joining our webinar today. I'm Aswini Weereratne, and I'm a member of Doughty Street Chambers. I'll be chairing the webinar this afternoon, which is being brought to you by the Doughty Street Inquest team and is the first in a series of webinars. So a few housekeeping points to start with. Please send in your questions using only the Q&A function and not the chat function, and we'll endeavour to answer as many of your questions as possible by the end, at the end of the webinar, failing which we'll collate the questions and answers and email them out to participants later. We're aiming for a prompt 5 p.m. finish. This session is being recorded and you will get the recording and slides sent to you after we finish. So today's topic is about ensuring effective inquests following deaths in the community due to COVID-19. We remain in the grip of a pandemic that's required draconian restrictions on our valued freedoms in order to prevent the spread of infection and to save lives. Yet the UK government has come under sustained criticism for its slow response to the pandemic, its failure to comply with WHO guidelines for self-isolation, its failure to provide protective equipment for frontline workers and others, its failure to anticipate and prepare for the risk to those in care homes and other congregated care settings, the failure of timely testing and now tracing, and for easing lockdown restrictions too soon and seemingly without scientific opinion in its favour. The death toll has been massive. As of today, close to 40,000 people have died from COVID-19 in the last few months. On Saturday, as lockdown was being eased, the Financial Times reported that the current daily death toll remains higher than on the 23rd of March, when lockdown was first announced. And currently, 8,000 people are still being infected daily. So regrettably, it looks like many more people will die before the pandemic is under control. The challenge for inquest lawyers is to identify where Article 2 inquests probing the circumstances of these deaths should be held, and to ensure that coroners conduct fearless investigations in the public interest. Deaths are occurring in disparate settings with different problems. Frontline workers and those in congregated care settings appear to be taking the brunt of the virus. Many deaths are of people with underlying conditions, which will raise causation questions. Government failures are a unifying backdrop, but an important debate is taking place as to whether or not the myriad criticisms of the government's responses are properly to be investigated by the coronial system, or whether a public inquiry is needed to examine failures in government policy. This debate has been fueled by the Chief Coroner's Guidance No. 37, issued on the 28th of April, on COVID-related deaths in workplaces, suggesting that coroners should not investigate such high-level government failures. So how should lawyers respond to this? We have two excellent speakers today who will consider these and other issues, Freddie Powell and Jessie Nicholls. We'll hear first from Jessie Nicholls, and Jessie will be examining arguments in favour of Article 2 inquests and the common law duty to hold a full, fair and fearless investigation in various settings, and questions around the Chief Coroner's Guidance No. 37. Jessie has extensive experience of acting in a range of inquests and public inquiries, mostly high profile, and engaging complex issues under Articles 2 and 3. He's acted for families in the Hillsborough Inquest, the Deep Cut Army Barracks Inquest, the Grenfell Inquiry, and currently the Bookhouse Inquiry. He's also counsel to the inquiry in the Manchester Arena Bombing Inquiry. He recently drafted inquest submission to the Chief Coroner on his Guidance No. 37. So over to you, Jessie.
Thank you very much, Aswini. The first slide's just come up and you should all be seeing that in terms of the aims that I have in mind. And that is essentially the aim of trying to achieve inquests which can ensure that deaths in the community from COVID or suspected COVID deliver the justice and answers that families of those who died want, and which they deserve and which we as the public deserve, to ensure that lessons are learned and prevention is emphasised as far as possible. Before I push through to the rest of the slides, I want to pick up on a couple of the points that Aswini made in her introduction, because what I'm going to be doing in the next 20 minutes is essentially talking about what we can do about three of the core points that Aswini made. The first is that, as Aswini mentioned, people in care settings in the community appear to be taking the brunt of this virus when it comes to fatalities. Obviously, everyone's very aware of the significant numbers of deaths in care homes and other community care settings that are taking place. There's been extensive reporting about the suggestion that the government essentially allowed the spread of infection to rapidly occur by allowing the discharge of those at risk of COVID from hospitals into care settings in circumstances where there was not adequate preparation for that to take place, including a failure to provide adequate PPE into the settings that people were being discharged into, and that had the effect, initially at least, of masking the death rate, because it was giving the impression that people who were dying in care homes were not dying from COVID, whereas they were monitoring the numbers of people dying in hospitals from COVID, and people were being discharged rapidly from hospitals into care settings. The other point that Aswini obviously made, and quite rightly, is that the issue that arises there is whether the state prepared adequately for that risk and implemented policies and procedures to try and guard against it. And similarly, in that context, and also in others involving healthcare and frontline workers, whether the state prepared adequately to ensure there was sufficient PPE and of sufficient quality to protect those who were arguably going to be most obviously at risk of contracting the virus and then passing it on to those who would be most vulnerable to succumbing to it. And so essentially what I'm trying to talk about is that sort of case, or those sorts of cases, and what we might be able to do as family representatives to ensure that there are effective inquests into those deaths that deliver the justice and answers that families need, and also deliver the justice and answers that we as wider society need in circumstances where, as Aswini has said, the state has taken on the responsibility of an enormous infringement of our liberties in the name of public protection. And it can be argued that that infringement has not been conducted in the way that it should have been to minimise death so far as possible. I'm going to move on to the next slide once it's up on screen. This is probably obvious from what I've just said, but when I say here limits, what I mean is I'm not in the next 15 to 20 minutes intending to talk about the arguments that we might make for having a coronial investigation culminating in an inquest, let alone a Middleton Article 2 inquest into every death from COVID-19 in the community. Now, there might be suggestions made that a public inquiry needs to investigate, for example, whether or not we went into lockdown soon enough, and therefore, for example, whether some deaths occurred not in the sorts of settings that I'm talking about as a result of a failure of government policy. That's not what I'm talking about in this webinar. There may be arguments about that, but for these purposes, particularly given time and also focus on state accountability and where Article 2 arguments are likely to be strongest, I'm going to focus on those settings that I've already mentioned. The other limits to point out are the last two bullet points in that slide. So one must bear in mind and anticipate that in making any of the arguments that I'm talking about, and which Freddie is going to come on to talk about when he deals with some of the practicalities of how we might go about making submissions and arguments to individual coroners, that there are going to be difficulties posed that do not normally apply in most inquest death cases, because the lack of testing means that we may often have to be saying that there is suspicion of COVID-19 as a or the cause of death, and that is sufficient to justify an inquest in circumstances where there is an argument of state responsibility that either engages Article 2 or the common law duty, or both. The next slide deals with the context that I've had in mind, and I think I've touched on those already. Essentially, they were picked up quite rightly by Aswini in her introduction, and I'm not planning to say anything more about them. Keep those in mind as the factual scenarios that I have in mind when I briefly come on to talk about the Article 2 duties that might be said to apply, and which we might want to be making submissions on to coroners in order to try and ensure that coronial investigations, at the least at this stage, are opened and then suspended. The purpose of making those submissions is essentially to achieve what is set out in this slide. So that is to say that you are seeking to convince a coroner that the inquest and coronial investigation into the particular death is one in which the state is under a duty to conduct an effective investigation and that complies with Article 2 and meets the purposes of an Article 2 effective investigation. Now, I imagine that most who are involved in this webinar will be very familiar with those purposes. Essentially, they're set out in cases like Amin at paragraph 31 and also summarised to a degree in the Chief Coroner's guidance on narrative conclusions. That is to say, ensuring as far as possible the full facts are brought to light, that discreditable or culpable conduct is exposed, suspicion of deliberate wrongdoing is allayed, dangerous practices and procedures are rectified, and crucially that those who've lost loved ones at least have the satisfaction of knowing that lessons learned may save the lives of others. That has particular poignancy in this context because it's envisaged that there may be further peaks of this virus, and in those circumstances the importance of lesson learning, whether that's through inquests or a subsequent public inquiry, is essential. We're not now talking about something that will not happen again and which is okay to leave and learn lessons from in 4 years. There is the real risk that if lessons are not learnt now, hundreds if not more of people will die as a result of the same kinds of failures that have occurred already. The question that one is putting to a coroner and then seeking to answer in favour of bereaved family in these contexts is essentially the one at the 4th bullet point of this slide. So, can it be said that it appears that one or other of the substantive obligations under Article 2 has been, or crucially may have been, violated, and it appears that the state may in some way be implicated? Now, if one reads that with the subsequent bullet point, that is to say that an arguable breach, which is all one needs to show at pre-inquest stage, is more than merely fanciful. If you put those two together, what you're in fact having to show is a low bar of state engagement and responsibility in the circumstances of death. And that should be emphasised, I would suggest, at the outset when making submissions to coroners on the investigations they need to conduct. The final point is also picked up on in later slides, but essentially comes to this. At the moment, where there has been no public inquiry announced by the government, and there are essentially no other means by which the Article 2 duty to conduct an effective independent investigation with the proper involvement of the bereaved family exists, inquests are the means by which Article 2 is discharged. So the coroner can't rely on any other measures as justifying not conducting a coronial investigation if it's shown that it's arguable that there's been a breach of the substantive obligations. That then begs the question, what are the substantive obligations that might apply in these sorts of cases? And essentially what I've tried to do in these slides is set out at a relatively high level the sorts of obligations that apply under the different limbs of Article 2 that we would say have arguably been breached in the circumstances of particular cases. Now, of course, I'm talking at a level of generality. Particular cases and their particular facts will give rise to particular submissions, but essentially the main argument is likely to be one under what's often known as the systems duty or the general duty. It's worth making an introductory point here that I haven't made in the slide, but it's often or sometimes suggested by state representatives at pre-inquest stage that this is a general duty at an extremely high level of generality. That is to say it's a duty where the state has to put in place a bare framework of laws. That's not right. It's very, very clear from the case law that there is such a duty. And for example, the state complies with that duty by having a criminal law in place to deter certain aspects of conduct that would give rise to a risk to life. This duty is not the same as that duty. This is a more involved duty, which can descend into the particularity of individual policies, practices and procedures within, for example, a particular prison, or more broadly, a particular NHS health trust, or more broadly, at national policy level in some cases. And the Article 2 duty involves a requirement on the state to put in place appropriate systems of that nature to minimise the risk to the life to the greatest extent reasonably possible. The key point for the kinds of factual scenarios I've touched on is the 3rd bullet point. So that is to say that in a range of other cases, the system's duty has been held to impose a number of duties that might be said to be relevant in these kinds of cases. The first is the provision of protective equipment in certain circumstances. I haven't included all the details of the cases, but they can be circulated if needed. And for anyone who wants the case citation, Smith, the 2011 case at para 105, Smith 2014 at para 6368, both make clear in the context of military operation death cases that Article 2 can extend to a failure to provide adequate equipment. There's also a case that's been cited in some of the discussion about COVID-related deaths from Strasbourg, which deals with inadequate face masks in a case called Brincat and Malta, which also appears to indicate that even where one is providing some form of protective equipment, it has to be adequate, and that in circumstances where it's not, an Article 2 issue may arise. Second sub-bullet point there, ensuring that equipment is in place, including at national level. I've flagged this point because there are a number of previous non-military Article 2 cases, albeit in different contexts, detention predominantly, where the courts have indicated that equipment and its adequacy to prevent death can fall within Article 2. So, for example, in Savage, the 2009 case, it was suggested that in the prison context, the wire netting that's used to prevent people taking their own lives by jumping from the high floors of prison blocks could fall within the Article 2 duty. And similarly, that the equipment and plant at a particular hospital or within a particular trust that needed to take account of the risk that patients might try to commit suicide could also fall within Article 2. Similarly, in Lewis, 2010 case in the High Court and the Court of Appeal, it was clear that the issue of ensuring that officers who respond to emergency calls of those who might have attempted to take their own lives by ligatoring have to have access to particular equipment to cut down those in distress very rapidly. So again, an example of equipment. There are others in those sub-bullet points that make essentially the same point in a wider context, that is to say systems, procedures, planning and training. And while those are not so directly relevant to the issue of PPE, they obviously are potentially relevant to the rollout of a state response to a particular risk to life. I flagged this case law, but I'm not going to talk about it in the webinar, just in the interest of time. There is a line of case law. It's not clear which sort of head of Article 2 it falls under, dealing with hospital systemic dysfunction. It indicates that in exceptional circumstances, Article 2 may be breached, essentially where there is a grave risk to the life of a patient from a serious illness, and there's something dysfunctional in the hospital system that gives rise to a failure to provide any medical treatment. There has been some suggestion that by analogy that might be used in these cases. I think there might be some merit to saying that. It's been limited by the domestic courts in Parkinson, and it's itself a very limited and exceptional category in any event in the Strasbourg case law. I think there are quite significant limitations and difficulties to trying to align it, but it's worth bearing in mind and looking at depending on the particular facts of a case. I won't dwell on this point, the operational duty, but the basic argument, this I think would be a more difficult argument and would depend on the evidence, but the argument would run like this. The operational duty arises in circumstances where there is a real and immediate risk to life, which the state knows or ought to know. The state then has to take reasonable steps in response. The Supreme Court in Raybone indicated that the duty is expanding, particularly at domestic level, and is young and capable of being extended. There are a number of cases in which it's said that the duty, that is to say a real and immediate risk to life, giving rise to the need to take reasonable steps, can apply to a large group within society, including where you can't identify the individual members within that group. So read in there, that might apply to those in a particular care home or those frontline workers who particularly need PPE. And in circumstances where the authorities know or ought to know of that risk, if they fail to take measures that might have been expected to avoid or minimise that risk, there can be a breach. And so the bar is relatively low. The difficulties are the ones that I've set out, and I think we can anticipate that coroners will pick up on those difficulties, but bear those points in mind. I've touched on the common law duty, in part because Chief Coroner's Guidance No. 37 doesn't touch on it at all. The basic point is, as well as the Article 2 duties, it's worth remembering, particularly given guidance from the Supreme Court in recent years about not arguing everything under the Human Rights Act, that there is an existing common law duty to investigate with sufficient scrutiny that reflects the seriousness and acute concern of a case. And so it's long been recognised that a coronial investigation must be full, fair and fearless, should not be slipshod, and must be sufficiently broad to meet the public interest, including by seeking out and recording as many facts concerning the deaths as the public interest requires. And given the particularly acute public interest in these cases, that's an argument that I envisage we may want to make. On the Chief Coroner's Guidance, I've basically sought to set out in summary form the arguments that we would need to be making as to why, if you get a coroner saying, yes, I hear what you say, but the Chief Coroner's guidance makes clear that this is not the sort of area where an inquest should be conducted, this is what we may want to be saying. First, that coroners don't follow guidance, they follow the law, and the guidance is not law. Second, the guidance makes clear that it's guidance, not law, because it says that it cannot fetter individual coroner discretion and that individual coroners should make their own judgments. It says that at paragraph 2. That can be relied on against the guidance where you're asking coroners to say that Article 2 is engaged. The most meaty aspect of any debate with a coroner on this is likely to be point 3. That is to say that the guidance says it's an expression of the law as it currently stands. And what I think we will need to be saying to coroners is that essentially it is not an accurate and complete statement of the law. There are a fairly large host of reasons why that is. One, because it doesn't give an accurate and complete description of the Article 2 duties. In fact, it doesn't actually refer to Article 2 at all, which is striking by its omission. If you rely on the duties that I set out earlier in the slides, the fact that those points are not in the guidance but may apply to an individual case would give a strong argument that the coroner should not follow the guidance but instead should follow the law. Second, even where there is reference to case law, including case law on Article 2, it's incomplete, partial and misleading. So the reference to Nicholls, for example, at paragraph 13, one needs to bear in mind that in that case, the inquest did look into systemic failures within the prison system, including policy issues, and the Court of Appeal approved that coronial investigation. What was actually an issue in Nicholls was a completely different question. The issue was not about the inquest. The issue was about a request following the inquest to have a public inquiry. And in that context, the court made the comments that the Chief Coroner cited, which is to say that in certain circumstances, a jury should not consider certain aspects within an inquest. So those comments were both limited to the issue of whether a jury should comment on it, and also obiter, because that wasn't the issue at play within the context of that decision. The reference to Smith, 2011, also per part 13, is also partial and misleading. Partly that's because it's obiter, because it was common ground before the Supreme Court in that case that there should be an inquest in which the coroner would explore systemic failures. It's also contradicted by multiple other passages in Smith, so paragraphs 87, 105, 106 and 217. It doesn't give any indication that Smith is a specifically military context case, which is potentially quite significant because those in the military choose to volunteer and put themselves at risk of death as part of their service. Obviously, they don't do that in circumstances based on completely deficient equipment, but that is not the same situation as healthcare workers or those working in care homes. They aren't putting themselves forward to be at risk of death as a result of enemy fire and so on. It also doesn't follow from the passage that's cited in the Chief Coroner's guidance that an inquest shouldn't investigate any part of the general policies and arrangements in place, because the example that's given in paragraph 81 that the Chief Coroner's guidance cites is that it would be inappropriate for an inquest to consider the issue of why there'd been no flak jacket. Now, what the comment actually makes clear is that it's dealing with the adequacy of protective equipment. If, for example, you had a PPE type case where there had been no provision of PPE whatsoever, that is not analogous with paragraph 81 that's cited by the Chief Coroner. In that situation, it would be arguable that the coroner necessarily should investigate that failure and why that had come about. And then the final point, which I think is a very helpful one, because it contradicts the fact the coroner is the Chief Coroner is issuing general guidance on this at all, is that the very cases that follow Smith, so Smith 2014, and also a case called Long 2015 in the Court of Appeal, make very clear that in those military cases, what actually needs to happen is that on the particular facts of the case, there needs to be a detailed examination of whether or not the facts fall within the Article 2 duties. And there's a detailed list of how one might go about conducting that analysis. That is not what the Chief Coroner's guidance indicates. It basically says this is not appropriate for consideration by an inquest, and that's misplaced. The final point to make, and this may carry some weight with coroners, is that where the Chief Coroner says that inquests are not the right forum, at paragraph 13, of course, inquests quite often consider the very matters that the Chief Coroner said should not be considered. And so that's worth bearing in mind. I'll touch on the final, I think, one or two, there may even be just one slide in, I hope, 1 minute. The relationship between inquests and public inquiry. The first point I've already made, in the absence of public inquiry, inquests are the means of discharging the Article 2 duty. It follows, as the second bullet point says, that coroners shouldn't be relying on the possibility of a public inquiry to refuse to even open investigations. That would be wrong. The Chief Coroner's Guidance itself envisages the approach that at least should be taken, which is that that an investigation should be opened and suspended. That's allowed for as a general discretion within paragraph 5 of Schedule 1 of the 2009 Act, and paragraph 14 appears to indicate that's what should be done. If a public inquiry is established, there is likely to be suspension of the inquests involved in those sorts of deaths that are likely to be covered by the inquiry. That is not a reason necessarily, well, it's certainly not a reason that inquests shouldn't be open in the first place, and it also may not mean that there should be no inquest at all following such an inquiry, because it completely depends on what the inquiry will do, what the terms of reference are, how broad it is, what category of case it will cover, how it will cover it, and then practically how effective it is when it's actually conducted, if there is a public inquiry. And so there may well be cases that fall into two categories. One, where inquests need to continue because the public inquiry is not going to cover them, and therefore they should carry on promptly to ensure compliance with Article 2. And two, inquests which should be suspended, but where there needs to be serious consideration given after any inquiry to whether they should be resumed. For example, to consider the individual circumstances of a particular death, because many inquiries into significant numbers of deaths simply don't look at that as an issue, yet that may be one of the most important aspects to the bereaved family of the inquest process, which won't be met by the inquiry. That's a whistle stop, and I've run over by, I think, 3 minutes. So I'm grateful to Freddie for his indulgence, and I hope that doesn't eat too much into his time. Obviously, I'll do my best to answer any questions that people have at the end, and I'll mute myself and hand myself back to Aswini.
Thanks, Jesse. Just to remind people who might have missed the starting comments, to use the question and answer button at the bottom of your screen to write and type your questions to us, which we will try and answer at the end. So next we have Freddie Powell, who will consider the practicalities of building a case and causation issues, amongst others. Freddie has represented families across a wide range of inquests. With his multidisciplinary background to the fore, he specialises in inquests from healthcare failures within and beyond clinical settings, including infection-related deaths and resultant civil actions. He has recently co-authored an article which considers the legal implications of failures to provide essential workers with appropriate PPE equipment, and has advised on the scope of the government's life assurance scheme for frontline workers who die in service. So before I hand over to Freddie, just to remind you that the question and answer session will take place straight after he finishes. So over to Freddie. Thank you.
Thanks, Aswini. I'm going to talk practically about how one can build a case around culpable and causative failures in respect of COVID deaths. And what we're advocating for here is a bottom-up approach to building a case, which looks for the obvious evidence and sees where it leads, meaning that the inquiry should start with the most local and proximate actors, such as the particular department, the care home or hospital, as opposed to the higher level governmental failures. And it's worth stressing as well that there's no one-size-fits-all approach. Different employees and different individuals have had markedly different experiences. Infection rates, availability of PPE, infection control measures will vary widely, and you will need to focus your case on the particular care home or hospital ward or bus depot in question. The final general point to make is that it may be reasonable in certain circumstances to request the suspension of an inquest to allow for evidence concerning matters of resourcing or policy to be obtained where that is necessary for a proper investigation. And that option is expressly contemplated by paragraph 14 of the Chief Coroner's Guidance No. 37. I first want to consider what evidence may be pertinent in respect of deaths in hospital settings, such as where a hospital worker is suspected to have died an unnatural death as a result of a failure to provide them with PPE. Potentially useful evidence here might include, firstly, evidence as to what the deceased told family or colleagues about the availability of PPE equipment. It's worth checking as well whether there was any contemporaneous records of those conversations, such as text messages. Secondly, whether there's any evidence about whether the deceased or their colleagues made whistleblowing complaints about PPE shortages and what was done about those complaints. Was there any evidence that staff were discouraged from whistleblowing or raised those concerns informally? Thirdly, the hospital should have conducted a specific and separate risk assessment for COVID-19. And when you're looking at this document, you need to ask yourself whether it adequately assesses and sets out a reasonable plan to mitigate and or eliminate the risk of infection. Fourthly, the infection rate amongst colleagues. A member of Doctors Association UK has said to me that the antibody testing of staff members has revealed that in many hospitals about 70 to 80% of staff have been exposed to the virus. And that may be data which is useful, as I'll explain shortly. Fifthly, it's important to examine the cause of death report. Now, in a hospital case, that may be provided by a hospital doctor, or if they're not sure about the cause of death, there may be a pathologist report. You may need to have an expanded statement from them. And if their evidence is uncertain or uncontroversial, you may want to call them as a witness. Finally, on this, it may be necessary to have evidence from a senior management employee within the NHS Trust to deal with the provision of PPE within the department or hospital. And so the suggestion that I make is to follow the evidential chain from the trust upwards if necessary. Nextly, I want to look at cases where residents or staff in care homes are suspected to have died unnaturally from COVID. And when building this case, it should be borne in mind that in contrast to deaths in hospital settings, care home residents have overwhelmingly died without being tested for COVID-19, at least in the period March to May 2020. So similar evidence may be useful here from staff or family members, any disclosure about other confirmed or suspected cases, any concerns raised by the family or other families, staff whistleblowing disclosures, the COVID risk assessment. And on this, it's worth specifically investigating whether it assessed and made plans in respect of the risk of admitting untested patients from hospital settings, which is a point that Jesse raised earlier. There should also be a cause of death report, which may need to be challenged, especially if there was no pre-mortem testing. And finally, it may be necessary to have a statement from the clinical director setting out the steps that the care home took to assess and meet the risk of COVID. In relation to deaths in detention, individuals detained in prisons, immigration removal centres, young offender institutions, secure training centres, and in other detention facilities may be exposed to a heightened risk of injury by being placed in cramped and unsanitary conditions. And the Ministry of Justice's latest guidance on COVID in respect of detention facilities contains precious little information about protective measures. And there's 2 points that I would highlight here. The first is that guidance contains no clear provision for enhanced screening, identification, and monitoring of those at risk or showing symptoms of COVID-19, even for those with underlying health conditions. And secondly, it's worth noting that the isolation timescales in that guidance are inconsistent with the WHO guidance, which recommends a 14-day isolation if you're symptomatic, whereas the Ministry of Justice's guidance recommends just 7 days. And I think the onus would be on the prison to show that they had complied with the Public Health England guidance regarding protective measures. Lastly, the point I would make about the risk assessment in this context is that one would expect the COVID risk assessment to have special regard to the heightened risk of serious illness and death faced by prisoners for a range of environmental factors compared to members of the general population. Briefly, in terms of public transport workers, Initially, we know that very few protective measures were taken. Some protective measures, which are referred to on the slide, may now have been installed. And it's important to focus on when those were installed, the reason for the delay, and the efficacy of those measures. In terms of causation, you will need to satisfy the causation test for inquests that's set out in Tainton by Sir Brian Leveson and Mr. Justice Kerr, meaning that you would need to establish, on the balance of probabilities, that the conduct in question more than minimally, negligibly, or trivially contributed to the death. And it's helpful, I suggest, to break that down further by asking yourself two questions. Firstly, did COVID-19 cause or contribute more than minimally, negligibly, or trivially to the death? Secondly, did the impugned conduct, on the balance of probabilities, cause the deceased to contract COVID? So that's two questions that you would want to interrogate in establishing causation. Firstly, did the patient die of COVID? And secondly, did the alleged failure cause them to contract COVID? Thinking about step one, you would need to show that the deceased had COVID-19. And in some cases, that may be straightforward because, for example, where a hospital worker who may have been tested positive while working or while subsequently treated as an inpatient. It may be more difficult to prove this in settings where testing was barely or not available. Now, there may be post-mortem testing by a histopathologist which would tell you whether a patient had died with COVID. And if clear evidence cannot be found that the deceased had COVID-19, then evidence of an outbreak amongst other residents or prisoners or staff may be a useful starting point in questioning the pathologist or cause of death report. Once you can establish that the patient died with COVID-19, it may be necessary to obtain expert evidence from a respiratory physician, ideally with a specialism in infectious diseases, and potentially others, to identify whether COVID-19 was an ultimate contributing factor or cause in the death. That may be important where, for example, there are multiple suspected causes. For example, someone with underlying health conditions, and the proximate cause of death, such as the heart failure or the bronchopneumonia, may not be the ultimate or real cause. Where it's not possible to identify the main or the ultimate cause, you can still satisfy the Tainton test by showing that the conduct contributed more than minimally to the death. And it should be noted that if there is a civil claim, then that takes you into the more difficult realm of material contribution. Lastly, the courts have emphasized that the absence of a clear cause of death does not preclude a careful causal analysis of the alleged failure. See the recent High Court case of Chidlow, paragraph 52. Step 2 of the analysis: did the impugned conduct cause the deceased to contract COVID? Now, the challenge here will be to prove that the deceased contracted COVID through their exposure to a high-risk setting, as opposed to a non-culpable exposure in the community. For example, TfL may say about their bus drivers that they could just as easily have contracted COVID from family or persons outside work. So the following may assist in proving the chain of transmission. It may be worth inviting the coroner or jury to draw inferences where there are blatant failures to create a safe plan. For example, where COVID has run rampant in a care home, it may be clear in some cases that the non-culpable explanation will not adequately explain the death. Secondly, expert evidence from a respiratory physician and or an expert on the effectiveness of PPE equipment and other infection control measures. In relation to epidemiological evidence, that may be relevant, although as Mr. Justice Pepperell observed in Chidlow, it's unlikely to be sufficient on its own. So specific consideration has to be given to the individual circumstances of the deceased. And the best way I suggested to adduce this evidence would be via a respiratory physician, because they should be able to cite and interpret relevant data in their report, as was done successfully by the claimant in Chidler. Lastly, I want to just flag that it may be arguable that the burden of proof in respect of causation should shift to the employer or care home owner to prove that the failure to conduct a risk assessment did not cause the employee to contract COVID-19. Now, that's an argument that has been tested successfully in a number of recent civil cases by the Doughty Street Clinical Negligence and Personal Injury Team, such as in the case of Goldscheider against the Royal Opera House. And it's clear that the court in Chidler were open to consideration of the civil case law on causation. Lastly, I want to flag that possible causes where it's not possible to show on the balance of probabilities that the conduct more than minimally, negligibly, or trivially caused the death, it might be necessary to rely on the coroner's discretion to leave the jury potentially causative factors, as in the case of Lewis. I hope that's been helpful, and I now pass you back to Aswini.
Thank you very much, Freddie. So we have got 3 questions in the question and answer panel. So I wonder whether I might just ask one of you to start us off with responses to those questions. Jesse, shall I turn to you first, and then I can, and then Freddie can follow?
That'd be helpful. Thanks, Aswini. If it's okay with Freddie, what I had in mind was to cover the first 2 questions because they seem to deal with the topics that I was covering, and I have thoughts on the third, but Freddie, perhaps you want to lead on that and I'll feed in anything if that would be helpful.
Great.
So I'm assuming everyone can see the questions. Yes. So the first question is the one from Elkin Abrahamson. Given the massive variation across the country of the approach by coroners to COVID-19 deaths, giving the example of the Channel 4 coverage at the end of last week, which indicated that in some jurisdictions, dozens and dozens of inquests, or at least investigations, have been commenced, whereas in others, nothing is being done. Other than judicial review, is anything being done to ensure consistency? For example, speaking to the Chief Coroner, the answer to that is that representations to the Chief Coroner in relation to the Chief Coroner's Guidance No. 37 have been made by Inquest to identify the flaws in the guidance, to set out the ways in which it should be changed, and to invite him to change it in order to satisfy the needs of bereaved families and the wider public in the way that I discussed briefly in my short presentation. Other organisations apart from Inquest are likely to have also done the same, given the interests that are involved. So far, the Chief Coroner has not altered the guidance, and in the response that was sent to Inquest, essentially said that he did not need to because there was sufficient generality within the guidance as it already stands. It wasn't intended to be a comprehensive explanation of the law, and individual coroners can conduct their own individual judgments, and he's not seeking to fetter or prevent them in doing that. Obviously, Elkin's question foreshadows one route that may be used, which is judicial review, and one can see different ways in which that judicial review could be advanced and who might be in a position to advance it. I think, unfortunately, at the moment, that's where we're at. The only other avenue would be to try and use the response that the Chief Coroner has provided to Inquest or potentially to others to indicate that he is not seeking to prevent coroners doing what Freddie and I have suggested in this presentation. The way in which he's responded to Inquest indicates to me that he's slightly concerned, and what he's seeking to do is play up paragraph 14 of the guidance. So for those of you who know it, paragraph 14 is the section that says this guidance doesn't stop individual coroners if they want to from looking at allocation of PPE within particular hospital trusts. But obviously that immediately follows the preceding paragraph 13, which says Inquest would not be the forum for doing this and they shouldn't do it, basically. It may be that circulation of that response from the Chief Coroner is helpful because it indicates to coroners that the Chief Coroner is not saying to them, you can't do this. I mean, the sad reality is he shouldn't have issued the guidance in the terms that he did, and it would have been much more helpful had he made clear, rather than digging his heels in, that there were aspects of the guidance that could be helpfully changed in a constructive way that would be useful to coroners. That would have been a helpful thing to have done, but it hasn't happened.
Jesse,
yeah.
Apologies, I'm going to jump in because people are saying that they can't actually see the questions. So I don't know whether you could just help them out.
Well, I'm hoping that the answer I just gave, given that I read out the core of Elkin's question, but that's really helpful. Thank you, Aswini. If I take the next question, I'll just read it out. It's a short one. So this one is from James Camage. It says, is a COVID-19 public inquiry inevitable? And if so, when would it take place? So taking those two questions in turn, is it inevitable? I think it's very likely, but not inevitable. I don't trust this government sufficiently to believe that they will establish an inquiry simply because it is very obvious that one is needed. It's public knowledge that there have been proposed judicial review proceedings intimated to the government to compel it to establish a public inquiry now, and that those intimations indicate that a public inquiry should happen as soon as possible, not in a year or 2 years' time when the crisis is said to be over. Obviously, those legal proceedings may be pursued and may result in an inquiry. Whether that results in inquiry, and if so when, is obviously difficult to speculate on. As to when it would take place, if the government chooses to establish one, I can imagine they're more likely to say it should take place after what they describe as the end of the crisis, in order not to divert resources and attention. There are other more cynical reasons why they might want to do that. But at the moment, it's obviously still up in the air. And for the purposes of considering inquests, I think the key point is there is no public inquiry. The government hasn't said that there's going to be one, or given any confirmation that there will. And there's nothing in the Chief Coroner's guidance, although it can be seen between the lines, there is nothing in the Chief Coroner's guidance which suggests that coroners are entitled to rely on the possibility of a public inquiry as influencing what they do in the discharge of their statutory functions. And they can't, in my view. If they did that, it would be a material error of law. Freddie, I'll hand over to you to deal with the other question.
Thanks, Jesse. Sam asks, if a coroner is persuaded to inquire as to the absence of PPE, how far does the coroner have to go? The absence of PPE in the care home, in the local authority, or actions of central government? I think that's a really good question. And there's a limit to how far it's useful to talk in hypotheticals. But the approach that I'm advocating here is that one follows the evidence up the chain of management. And I think we would likely encounter resistance from coroners if family representatives are reaching for high-level failures before demonstrating them at the local level. In terms of how far they would go, I think the cases that are discussed by Jesse make clear that there's no principled limit to how far they could go in those sorts of, in an inquest. And so in answer to what the question you're putting, Sam, I would begin with the local care home. I would move on. If they turn around and say, well, we were on the phone to the local authority waiting for tests for 3 days and we didn't get a response, then the answer is to look to the local authority. And if they say, well, we were contracted with local government to do this and they didn't uphold their end of the bargain, then it seems to me that the failure would be located further up the chain. But I think the point that I was suggesting is that the experiences in terms of the availability of PPE seem to vary quite considerably in different areas, different trusts, different care homes, and there probably isn't a one-size-fits-all approach. Jesse, do you have any more thoughts on that?
No, that was essentially the thrust of what I was going to say as well, Freddie. I think it makes sense to start from the bottom up, work up in that way, and obviously look at the particular facts as to whether they justify going further up. You're also going to have to, in reality, be sensitive to how willing a coroner is to entertain the extension of the Article 2 arguments. Freddie is right, they get more difficult the further you go towards national policy, both on a legal level and also because that's obviously going to scare coroners. It would do anyway, and it particularly will do in circumstances where they have Chief Coroner's Guidance No. 37 in front of them. And even though I've set out all the reasons why there are glaring gaps and errors in that guidance, others will be representing health trusts and so on and telling them the opposite, and they will be worried about that. And so I think the approach that one needs to take is a balance between what's legally permissible what's practically achievable and what's tactically sensible on the facts of the particular case. It's essentially incremental to try and achieve as much as possible, I would have thought.
Thank you. Thank you very much, both of you. I think there may be one or two more questions coming through. May I just remind people to use the question and answer function, because that way the panelists will be able to read your questions and answer them. And we do have a few more minutes, so if you want to do that, please do so.
Sweeney, shall I pick up this final question that's been added just a minute ago?
Thank you very much.
Freddie, feed in here if you think there's anything I missed. It's from Elizabeth. Do you envisage us ending up in an almost fast-track inquest situation where COVID deaths, which on the face of them are likely to be natural causes deaths, will be fast-tracked to reach a conclusion where there will simply be too many to deal with and too many for NHS Trust to investigate by way of RCAs, for example? I think what's more likely to happen is that as a result of I'm more worried that as a result of the Chief Coroner's guidance, coronial investigations won't even be opened into these inquests at all, into these cases at all. I also think that because of the relationship under other pieces of the Chief Coroner's guidance between individual coroners and those who are reporting deaths to them, they may be taking such a restrictive approach that they're discouraging deaths even being reported to them in the first place, to even consider whether to then open a coronial investigation. So my concern is more that they're not going to get onto the consideration of them possibly being an inquest. I think if they become an inquest, that is also, Elizabeth's concern is one that may eventuate, but at least if it becomes an inquest, we have potentially have our foot in the door and an opportunity to tell the coroner why that should not be done.
Yeah, I think that's sensible. I think the volume or potential volume of inquests is not a valid reason to rush that they still have to be a full and fearless investigation. And it may be that there will have to be a number of root cause analysis reports, but those still need to be done. There still needs to be the evidence needs to be gathered in a proper way, and there shouldn't be corners cut simply because there are unfortunately more deaths that are going to have to be investigated by inquest. Right.
Thank you very much. I think that's the last question that we have. So I'm going to, I think, say that we have now come to an end. Before going, please note that the next inquest webinar is scheduled for the 17th of June, 4 p.m, and the invitations will be sent out nearer to the date. It's going to be hosted by Chiran Herseth and Christopher Johnson, and it's going to be covering COVID-19, postmortems, prisons, and virtual hearings. So please join us again on the 17th of June. So in the meantime, so thank you very much for joining us, and goodbye from all of us. Thank you very much.